Thank you all for coming and for your interest in this important set of issues, which obviously, given what's happening in the news right now, is more critical for us than ever as people who care about the Constitution. My name is Mitra Ebadolahi. I am a staff attorney with the American Civil Liberties Union in San Diego. I was previously a staff attorney with the American Civil Liberties Union in New York with the National Security Project, where I was part of the team that litigated NSA versus Clapper, the case challenging the FISA Amendments Act, which the Supreme Court threw out in February. I'll talk about that a little bit more in a moment. We are going to talk a little bit, each of us, about our various takes on surveillance and the NSA and whistleblowers, and then hopefully open it up for discussion and questions from you about this set of issues. And my purpose is to give you some background on how we came to live in the surveillance state that we are now in. And my sort of overarching message is that we are witnessing an abject failure to protect the Constitution on behalf of all three branches of government, the executive, our legislature, and our judiciary. And so the key question in my mind that I want you to think about as we talk is, how do we come to get to this point, and what do we do to undo some of this damage? Just to start at the beginning, or where I think the beginning is, in 1975, the Senate formed a bipartisan committee known as the Church Committee, and it was designed to investigate allegations of surveillance abuses committed by the executive. The Church Committee reviewed the activities of various United States agencies, including the FBI, the CIA, the National Security Agency, the NSA, the Department of Defense, and the National Security Council. And it looked at the activities of those agencies for a period of time ranging from the mid-1930s through the mid-1970s. The committee found that intelligence excesses at home and abroad have been found in every administration, and concluded that many presidential administrations had collaborated with intelligence agencies to break the law and overextend intelligence operations. Specifically, the Church Committee found a pattern of intelligence investigations with vague or imprecisely defined mandates, which in turn provided intelligence officials enormous discretion with which to choose their intelligence targets. Often, the targets of government surveillance were chosen based solely on domestic political considerations. The most perhaps famous example was the FBI's targeting of Dr. Martin Luther King Jr. in an effort to, quote, neutralize him as a civil rights leader. The FBI used nearly every intelligence technique at its disposal, including electronic surveillance, to obtain information about Dr. King's private activities and to discredit him and his advisors. Also, between 1960 and 1972, the FBI subjected nearly 30 American citizens to electronic surveillance to determine sources of leaks of classified information. They found no such leaks. Instead, they conducted the surveillance without judicial approval and based on little or no individualized grounds of suspicion. At least 7 of their targets were journalists. And ultimately, what the FBI ended up with was a lot of personal information and political information about people who they had decided to target. In the end, the Church Committee issued a series of recommendations that were designed to better safeguard Americans' privacy, expressive, and associational rights. One key set of recommendations involved judicial oversight of intelligence operations. Specifically, the Church Committee identified 3 characteristics of U.S. intelligence that, unchecked, had led to violations of the rights of American citizens. And if I tell you what those 3 are, it'll sound like I'm talking about today. 1, excessive concentration of power in the executive branch. 2, excessive secrecy that shielded, quote, constitutional, legal, and moral problems from the scrutiny of all 3 branches of government and from the American people themselves. And 3rd, a general sense of lawlessness that pervaded the intelligence field, causing government officials to use national security rationalizations as a pretext on non-security, as a pretext to evade statutory and constitutional limits on non-security related surveillance. After the Church Committee issued its report in 1978, the Foreign Intelligence Surveillance Act, FISA, was passed into law. FISA set forth a comprehensive procedure through which, with limited exceptions, officials had to obtain a court order before engaging in any surveillance of communications to or from Americans located in the United States. The FISA scheme created a special court that was supposed to serve as a check on executive surveillance activities, the FISC. The government had to apply to the FISC for permission to conduct foreign intelligence surveillance in the United States, including surveillance of communications with American citizens into and out of the United States. The FISC application required identification of a specific target, the specific facilities or places used or about to be used by the foreign power or agent to which surveillance would be directed, a detailed statement of the facts or circumstances that gave rise to the government's desire to surveil that target, and minimization procedures designed to limit the extent to which that surveillance implicated the communications of the American people. In reviewing the application, the FISC judge was actually required to find, on an independent determination, probable cause to believe that both the target of the electronic surveillance was a foreign power or agent, and that foreign power or agent was using or was about to use each of the facilities that the surveillance was going to be directed at. After 9/11, George W. Bush secretly authorized the NSA to conduct surveillance of communications between Americans and foreign parties without FISC authorization, claiming his wartime powers. This surveillance, which was known as the Terrorist Surveillance Program, was just one part of the still secret President's Surveillance Program, a much larger program about which we still don't know everything. The TSP, the Terrorist Surveillance Program, was revealed through a series of groundbreaking news reports in 2005, resulting in public outcry. That led the Bush administration to pressure Congress to amend the FISA. The ultimate result was the FISA Amendments Act of 2008. The FISA Amendments Act allows the executive branch to circumvent many of those key judicial safeguards that came out of the Church Committee recommendations and led to the original form of the bill in 1978. Unlike the FISA Amendments Act does not require the FISC to issue an individualized order after meaningful judicial review, and does not permit the FISC to engage in continued oversight of ongoing surveillance. The statute eliminated the probable cause and individualized suspicion requirements, and the government can now obtain orders authorizing surveillance for up to 1 year simply by certifying to the court without any independent review that its targets are reasonably believed to be located outside the United States. What that means is that our communications can be swept up as long as you're talking to someone who's outside of the United States. The FISA Amendments Act thus has dire and immediate consequences for those Americans engaged in routine international communications with clients, sources, witnesses, experts, dissidents, and advocates abroad. It opens up our international emails and telephone calls to warrantless surveillance, impeding the confidential communications integral to such professional and personal activities. Immediately after the FISA Amendments Act became law, the American Civil Liberties Union filed a lawsuit challenging the statute's constitutionality. Our plaintiffs included attorneys and human rights, labor, legal, and media organizations whose work required sensitive and at times privileged international communications. The government, including the Obama administration, argued that the plaintiffs lacked standing to sue because we couldn't prove to a certainty that we were being secretly surveilled. Notwithstanding the uncontested fact that the government was engaged in the very types of surveillance that the FISA Amendments Act was designed to allow the government to collect. The Supreme Court heard argument last October, and this February held that we could not satisfy Article 3 standing requirements, throwing our lawsuit out. Justice Alito's majority opinion identified a, quote, highly attenuated chain of possibilities insufficient to establish that our alleged injuries were certainly impending or fairly traceable to the FISA Amendments Act, and emphasized that we cannot know whether we have been subject to secret government surveillance pursuant to the FISA Amendments Act or instead other authorizations. A powerful dissent from Justice Breyer explained that the majority forgot to assume that the government is just doing its job to conclude that there's a high probability that we are in fact being surveilled. Unfortunately, Congress reauthorized the FISA Amendments Act for 5 additional years last December with not a single amendment designed to protect our constitutional rights or increase our privacy. So that's how we came to where we are. The FISA Amendments Act is one of the many pieces in this very troubling mosaic eroding our core constitutional values and our privacy rights. And Lee now is going to talk about additional efforts to, through litigation, hold our government officials more accountable.